Good afternoon. I want to welcome you to the 11th annual Rush McKnight Labor Law Lecture. This has been an important lecture in the field of labor and labor law and legal education. The Rush McKnight Visiting Scholar in Labor Law program was established in 1997 by the firm of Calfrey, Halter, and Griswold. Any members of the firm here? And by Richard J. Cusick, Charles R. Emmerich, and Joseph D. Sullivan to honor retired partner Rush McKnight, a distinguished graduate of this law school in 1955. Ms. McKnight headed the Calfrey, Halter, and Griswold labor law and employment relations practice and the executive committee for many years. Prior to joining the firm in 1961, he served as attorney advisor to the chairman of the National Labor Relations Board. Ms. McKnight is a civic leader in Cleveland, a dedicated supporter of the law school, and having served as, for example, chair of the Law School Annual Fund and as president and vice president of the Board of Governors of the Law Alumni Association. He's also a member of the law school's Society of Benchers. Just to give you a sense for this lecture, I thought I'd indicate some of the luminaries who have delivered this lecture in the past. Those have included Matt Finken, the Albert J. Harno and Edward W. Cleary Chair in Law at the University of Illinois, Cynthia Esslin, the Catherine A. Ryan Professor of Law at NYU, Jack Getman, the Earl E. Sheffield Regents Chair at the University of Texas, Kai Feldblum, Professor of Law and Director of the Federal Legislation Clinic at Georgetown Law Center, Stuart Schwab, the Dean and Professor of Law at Cornell, Clyde Summers, a name you'll recognize, the Jefferson B. Fordham Professor of Law Emeritus at the University of Pennsylvania, Houghton Sheedle, who's a Professor of Law at the University of Cape Town in South Africa, Catherine Stone, the Ann Estabrook Professor of Dispute Resolution at Cornell University, Marion Crane, Paul Eaton Professor of Law at the University of North Carolina, Sam S. Stryker, the Dwight D. Upperman Professor and Director of the Center of Labor and Employment Law at NYU. So, as I say, a fairly long list of luminaries, and today's lecturer continues this stellar tradition of excellence in the field of labor and employment law. He's a University Professor Emeritus, former Dean of Osgoode Hall, and President of York University. He's been an academic visitor at Oxford, Cambridge, and University College in London. Since his retirement, he has served as Commissioner to review Canada's labor standards legislation and Ontario's workplace pension system. He's published widely in the fields of legal education, the legal profession, legal history, legal theory, labor and administrative law, globalization, and in recent years, constitutionalism. The breadth of his academic contributions have been recognized by his election as an associate of the Canadian Institute for Advanced Research, a fellow of the Royal Society of Canada, and the corresponding fellow of the British Academy. He's been awarded the Canada Council's Killam Prize for his lifetime contributions to the social sciences and the Boyle Laskin Prize for his contribution to labor law. In 2008, he was a co-winner, along with Joseph Stiglitz, of the ILO's Decent Work Research Prize. He's a member of both the Order of Canada and the Order of Ontario and has received 9 honorary degrees. In addition to serving as an arbitrator and mediator in labor disputes, he's conducted inquiries and reviews at Canadian, British, and American universities and has provided advice to governments on issues ranging from higher education policy to constitution to labor and employment law. He's also served as a bencher of the Law Society of Upper Canada, a member of the Economic Council of Canada, and president of the Canadian Civil Liberties Association. And this is the short version of what is obviously a highly distinguished resume. Some labor colleagues and I had the great pleasure of working with him on a recently published text on international labor law where he proved to be an advisor of great insight. So I'm truly delighted to welcome as our 2009 Rush McKnight Lecturer in Labor Law, the Honorable Harry Arthurs, who will talk to us about the mysterious disappearance of labor and labor law. Please join me.
Well, thanks, everyone. Exactly 101 years ago, my grandmother, Dora, came to Cleveland to train as a nurse and midwife. Perhaps she came because some cousins lived here, or perhaps because the city had a fine reputation as a medical center. In any event, while a student nurse, she met a doctor here in Cleveland who tried to persuade her to stay on and study medicine. Personally, I think he had something else in mind, but we will never know, because she took her diploma and returned to Toronto to the man she loved, a man named Adolph. However, after a year, she dumped Adolph and married instead my grandfather, Harry, for which I am eternally grateful, because otherwise I would be Adolph. Now, I've shared this family history with you, partly in order to establish my local credentials, but partly because it's part of the background of my talk. My grandparents, Dora and Harry, launched a successful business and made lots of money. But they were both closely identified with the labor movement. Every weekend, Harry would go down to the local jail and bail out union workers awaiting trial for bad behavior on the picket line so they could go home to be with their families. Harry raised the money for the local garment trades union hall. He ran for city council on the labor ticket. And after he was killed in a car accident, Dora carried on the family tradition. She was closely involved with the Toronto Labor Council, and until the day she died, she was the honorary secretary of the Toronto Bagel Makers Local. What a distinction. In those days, and in fact, pretty much well into the 20th century, in most countries other than the United States, to declare oneself a labor person didn't necessarily mean holding a union card. Often it meant committing oneself to the advancement of working people through political and social action. Labor was a political as well as an industrial movement. And labor wasn't just a label one chose for oneself. It was also a sociological term that described people who worked for a living with their hands, often a relatively precarious living, with no job tenure and none of the benefits we now associate with employment. It was widely assumed that the laboring classes were different from the rest of us. that they had their own special needs and desires, that they posed particular dangers to the community, that they enjoyed a distinctive, if sometimes disreputable, cultural life. And if there was one thing that they were not, it was middle class. Now, all of this may sound like ancient history to a contemporary audience, and it is. Nonetheless, most of what we know today as labor law had its origins in the social, cultural, political, and legal world of my grandparents. For better or worse, that world is gone forever. In the next part of my lecture, I'm going to explain how and why labor has disappeared. And then I'm going to suggest that labor's disappearance threatens the substantive content, the coherence, the practical importance, and the moral significance of labor law, of labor scholarship, and of legal practice in the field. And finally, I'm going to surprise myself and perhaps you with an optimistic glance at the future. In the interests of covering a lot of territory in a very short time, I'm going to walk you briskly through a series of slides that summarize certain changes in the workplace, in the general discourse of public governance and legal theory, and their effects on labor and labor law. I begin with a series of disclaimers. First, I'm flying at 30,000 feet and dropping no footnotes. Second, I'm trying to describe change and not to justify it. Third, I don't argue that labor disappeared solely because of its obsolescence or irrelevance. Rather, I think, to a certain extent, labor has been disappeared in the Latin American sense of that usage. And finally, my slides contain scenes depicting violence and coarse language and are intended for mature audiences only. So, with that warning, let me walk you briskly through the mysterious disappearance of labor and perhaps of labor law. We all know that there have been lots of changes in the way workplaces function and are organized. Here are some of the shifts that have been very influential. We all know about the shift from manufacturing to the service economy, from human power to machine power, from human intelligence to digital intelligence, from concentration of production, where firms make the things they ultimately sell, to extended production chains in which they buy in a great deal of what's ultimately incorporated in their product. And we know, of course, about the shift from local to remote and indeed global management of the enterprise. As a consequence, we've witnessed the radical enlargement of the world supply of labor, and as well a new international division of labor. Countries are assigned different tasks. Their labor forces, at least, are assigned different tasks. There's been a decline in domestic demand in all of the advanced economies for unskilled and semi-skilled labor, and an increase in domestic demand in those countries for knowledge-based and high-skilled labor. And these shifts have had implications for the very existence of what we came to know as labor. They've been associated with a loss of bargaining power for most unions, a loss of solidarity within and amongst unions, concepts such as community of interest, which were used to describe bargaining units. Now that community of interest is much more attenuated. There's been a significant decline, I think, in international working class solidarity, and some people most people at least perceive, and the decline of collective bargaining, many people perceive that the game is all over. Likewise, union political power. And here I'm speaking not only about the United States, but about almost all Western countries. And likewise, the decline of unions' participation in high-level public policy discourse. Now, these shifts in the way work's being organized are paralleled by changes in the population of the workplace and in worker identities and consciousness. We've certainly moved, I think, from relatively homogeneous to highly heterogeneous workplace populations, diversity in the workplace. From the acceptance of discrimination in the workplace, that's how you keep these workplaces homogeneous, to the contestation of that discrimination. It's still there to some extent, but we no longer accept it. We now combat it with legal and other strategies. A shift from working class collective identities to what I call essentialized or individualized identities associated with gender, geography, generation, religion, and so forth. And finally, people now, I think, tend to identify themselves more as consumers than producers. I wear a certain brand of clothing, I support a certain sports team. That's an identity that's much more important to me than the fact that I work, I was about to say in an auto factory, but that just dates me. But a shift, as I say, from being a producer to being a consumer. And that's had a number of consequences. You'll see some of these themes recurring. A weakening of working class solidarity, tension within working class organizations, the centrifugal effects of competing loyalties, pulling people away from their natural interest, for example, as participants in a labor union to other activities, leading to various political developments, depending on which side of the fence you're on. There's a wonderful book by Thomas Frank that I reference here, One Market Under God, showing how religious and other cultural affinities have pulled people away from concentrating on their own economic interests, or in a much more benign view, an evolution towards worker capitalism, if that happens to be your view of what's going on. And all of this, I think, has substantially undermined the labor-based political coalitions which date back to the New Deal. So these developments, in turn, have had implications, again, for this whole notion of labor. There's been a loss of what I call a category status. That is to say, it isn't the first thing that comes to your mind when you're talking sociology or culture or politics. To talk labor as a collectivity with a presence, that dates you. Labor has significantly disappeared from the media, from academic and professional discourse. It's no longer a subject that occupies headlines as it once did. And going along with these developments, then, a decline, or in some cases what I call a hybridization of professional practice and academic careers in labor law, which is a fancy way of saying it's pretty hard to make a living as a labor lawyer. You've got to find other things to do on the side. Changes in workplace governance. Where once planning was thought to be very important, not only for governments, but for corporations, flexibility has become the watchword today for corporate strategy. From a period when we had what I call thick hierarchies of management, multiple layers of management, many of those layers have now been tossed aside. Management structures which operated on the old command and control model now operate with a devolution of management responsibilities to worker groups who have to discipline themselves and each other, where, for example, a group is collectively responsible for output. If anybody's lagging, it doesn't take the foreman to come down on their head, but fellow members of the team will ensure that productivity is maintained. From what I call semi-tenured employment, that is to say, people who could reasonably expect long careers in their job, to employment which is highly contingent. Job tenure, the length of job tenure has fallen really dramatically in the last 20 years. From having rights in the workplace to being given choices in the workplace. From entitlements, things you go into the workplace expecting, entitled to, you now can expect, if you're lucky, to find them, but you're no longer entitled to them. And there are consequences. Collective responsibility for things like your health, your retirement, collective responsibility embodied in health and pension plans has been replaced to a significant measure now by individual responsibility. You've got to look after yourself. Worker agency, the capacity of workers to get things done in their own interest has been replaced to a significant extent by passivity on the part of workers. Workplace conflict, real or threatened. What got the boss to listen was the possibility of conflict. That's now been replaced, especially now in a desperate job market, by the watchwords of cooperation, leading often to co-optation by workers in the employer's strategy. So once again, this notion of labor is impacted by these developments. And look at some of the changes we're displaying here. Changes in terminology. Today, we say the Human Resources Department instead of the Industrial Relations Department. We talk about employment law instead of labor law. That terminology signals, I think, a big change. There's been a change in what I call legal and conceptual logic. Instead of talking about labor as organizing a body of law, we now talk about the old legal categories of tort and contract and constitution and property. Emphasis in teaching in law schools, much more now on teaching individual employment law than on the old collective labor law. And in professional practice, an emphasis on vindicating the rights of individuals rather than using labor law to promote the collective mobilization of workers. Finally, then, a few words about public governance and legal discourse. It seems to me, generally speaking, that we've moved a long way from the time when we used to talk about justice and politics in our general discourse, to the present when we talk much more about efficiency and economics. That's certainly true in academic circles. I think it's true if you read newspaper editorials. I think it's become a new part of our consciousness that efficiency, economic considerations trump considerations of justice. We've moved from having purely national regulatory systems to having systems which are either transnational or subnational, that is to say, from federal to state, or from the nation up to transnational agencies. Many people know, for example, that the World Trade Organization has been nominated as one of the best ways to look after labor's interests in the context of globalized economy. Strategies of regulation have changed. From command and control to new systems of indirect regulation. That is to say, you give people incentives to behave rather than tell them that if they don't behave, they will be punished or made to pay damages. From public governance to various forms of hybrid public and private governance. Those of you who are lawyers will know, for example, about the shift in the enforcement of many regimes of workplace regulation away from public agencies to private arbitration. captures that notion, and from hard law enacted by the state to soft law, things like corporate codes of conduct. Consequences. Domains of public policy which were based on the old discourse have disappeared. Along with them have gone the moral imperatives and legal logics and the institutional forms associated with those old policy domains, and new domains emerge with their own distinctive imperatives and logics and institutions, which are shaped largely by fiscal, by economic, by trade, by security, by human rights concerns, but no longer, I think, primarily by concerns for working people as such. Consequences for the notion of labor. I've tracked the disappearance of labor departments in many, many governments, both across America and around the world. Their previous functions are now absorbed into departments of trade or industry or economics, or shunted off to welfare-related departments. Labor vanishes from the executive and legislative agenda. You will all know the last time the National Labor Relations Act National Labor Relations Act was amended essentially, 2-3 generations ago. All attempts to amend it, at least up to the present, in the interim, have been unsuccessful. Labor law policy and law, therefore, have not been modernized, and many labor scholars have sought other outlets for their work. So, to sum up the narrative I've just offered you in much too much of a hurry, virtually all of the social, cultural, political, economic, and legal foundations of labor law have been radically compromised. As a result, labor law will have to be pretty much rebuilt from the ground up. Let me offer you a few examples. Workplace solidarity is much more difficult to achieve if you have to bring together workers who are physically remote from each other, who speak different languages, have different ethnicities, work under different corporate structures, and are regulated by different legal systems. Think again anachronistically of the automobile industry today, its dispersal around the world, but particularly across North America. Compare that with the auto industry organized by the UAW in the 30s. In that new context, structures such as bargaining units based on community of interests and strategies such as concerted action to promote those interests, they have become much more difficult to sustain. Identifying the employment relationship as the site of job training, health insurance, or pension systems ceases to make sense when job tenure is brief and workers are unlikely to have a sustained relationship with any given employer. Workers become much more difficult to mobilize politically if their hot-button issues aren't shared concerns about economic justice, but rather quite disparate concerns about their personal identities, their moral values, and their lifestyle preferences. But without a strong collective voice in politics, workers can't expect labor-friendly public policies or legislation. And even if worker-friendly laws and public policies were adopted, it would be very difficult to give them practical effect, so long as judges and administrative agencies are people who are ideologically predisposed to favor free markets, so long as the state's regulatory apparatus lacks powers, resources, and legitimacy. I'm describing here the NLRB as it sits today. And so long as workers must try to defend their remaining rights through individual and not collective avenues of recourse. These examples suggest that labor law is likely to be in disarray, both as a subject of academic study and as a field of professional practice. And indeed, that seems to be the case. Compared to, say, the 50s or 60s, fewer law students are studying the subject. Fewer law professors are teaching it or writing about it. Fewer lawyers are practicing in the field. Fewer judges are deciding labor cases, and fewer legislators are spending time on labor law issues. Now comes the tough question. When I say that labor law is in disarray, what exactly am I talking about? What exactly is labor law? From, say, the 30s to the 70s, maybe even the 80s, American academics and lawyers conventionally assumed that labor law was about legal regulation of the collective bargaining system. True, in the course of dealing with that system, both academics and practitioners had to be mindful of its roots in the common law of tort and contract, and they sometimes had to consider the interface between collective bargaining and other legal regimes regulating the workplace. However, the core, the essence of labor law scholarship and practice was surely collective bargaining. Today, with union density in America running below 8%, if you are in the business of selling the law of collective bargaining to prospective clients, to JD students, to journal editors or book publishers, you confront a declining market for your wares. On the one hand, the political economy of professional practice has changed. As fewer workers belong to unions, fewer leading national and international law firms bother to maintain labor law departments. The practice of labor law has migrated largely to lower-profile regional firms, to in-house corporate or union law departments, and to boutique labor firms. On the other side, collective bargaining has largely ceased to impinge on the consciousness of most law students, or for that matter, many younger lawyers and law teachers. They probably won't have studied industrial relations or labor history in college. They aren't likely to have experienced strikes firsthand or witnessed regulatory interventions in the workplace. Their friends don't belong to unions, and their families don't own or manage unionized enterprises. And finally, these two developments are likely to reinforce each other. As the prospect of practicing labor law recedes, or it becomes less visible and attractive, fewer and fewer students are going to sign up for labor law courses. And as fewer students study and fewer professors teach these courses, firms that still practice labor law will likely find it more difficult to renew their personnel and their intellectual capital. But the story is not quite that simple. The decline of labor law, of collective bargaining law, has been significantly offset by a shift of interest and energy to courses dealing with other workplace issues. Courses in labor and employment law now deal with both the individual and collective dimensions of workplace relations. New standalone courses and seminars in occupational health and safety, labor standards, pensions, employment discrimination, and international labor law have proliferated. Sports law and entertainment law have found a prominent place in the curriculum of many law schools, ensuring that privileged workers in these fields receive the special attention that their wealth and celebrity have earned them. The people who teach these specialized courses have, of course, been writing and publishing about their specialties. And I'd hazard a guess that these new domains of knowledge constitute a significant part of what most practicing labor lawyers need to know today to serve their clients. If that's so, if labor law is no longer just about collective bargaining, if it's reinvented itself as an array of legal regimes addressing a variety of workplace issues, then I've answered my own question. The disappearance of labor has not, in fact, led to the disappearance of labor law. But as you will have guessed from the fact that I'm only partway through my allotted hour, I have more to say on the subject. The problem's this. What used to give labor law its uniqueness, its intellectual coherence, its policy logic, its moral claim to our attention, was the notion that there is something unique about relations between workers and employers. An employment contract, labor lawyers believed, is not the same as a contract for the sale of land or lumber. Collective action in labor markets is not the same as collective action in other markets. Race and gender discrimination and other affronts to dignity in employment are not the same as similar discrimination and abuse in the education system or the purchase of insurance. And health and safety in the workplace are not the same as health and safety in transportation or consumer goods. When I say that the labor context is unique, that things are not the same in other contexts, I mean to point to three propositions that most labor scholars or practitioners once took to be true. First, employment relations are characterized by inherent inequalities of wealth, power, and rights. Second, inequality affects those relations in every dimension: contracts and collective action, discrimination and dignity, health and safety. And third, the mission of labor law, for better or worse, is to eradicate or to alleviate, or if you represent employers, at least to legitimate the consequences of this inequality. I think it would be fair to say then that unlike many other academic subjects and domains of practice, labor law, the old labor law, had a moral mission. At very least, it involved a debate over a moral question. Labor law wasn't just about distributing loss like torts or enforcing obligations like contracts or ensuring that government agencies lived within their mandates like administrative law. It was fundamentally and centrally about correcting the inequality and remedying the injustice that is characteristic of labor markets and of the legal regimes that traditionally regulated them. Under the old labor law, of course, lawyers disagreed about the causes and cures of inequality, about how its different manifestations compound or cancel out each other, or about the extent to which other values ought to take precedence over this focus on inequality. Management lawyers accepted that inequality exists in the workplace, but maintained that far from being problematic, it was the inevitable and appropriate result of the workings of free labor markets in a dynamic economy. Union lawyers, on the other hand, argued that inequality was morally wrong, that it diminished people's rights as citizens, and that it ought to be eliminated whether by enabling workers to exert countervailing power or by using the state's authority to prevent exploitation. Under the new labor law, things have got more complicated. Now some lawyers accept the traditional labor law diagnosis of workplace inequality, but reject the legal responses of the old labor law in favor of new remedies. These new remedies tend not to involve specialized labor legislation, doctrines, or agencies, but rather general constitutional or common law principles, or even soft law, I've mentioned before, such as corporate codes of conduct. And most importantly, more and more academics and practitioners see workplace inequality as merely a special instance of a larger category of social inequality, based not on class, not on the status of labor, but on race, disability, age, or gender. Fix that larger category, they argue, and the smaller category of the workplace will be fixed as well. These are all interesting and valid perspectives. I wouldn't want to discourage any of them. But they've had three important consequences. First, they've interrupted the moral debate posed by the unique characteristics of the employment relationship, a debate that lay at the heart of labor law. Second, they've bypassed the distinctive ideas, institutions, and processes by which that debate was translated into legal outcomes. Ideas, institutions, and processes that, as it happens, were also being simultaneously attacked by opponents of collective bargaining and other forms of labor market regulation. And third, they've expanded but also divided and diluted the so-called discursive community of labor lawyers, the people that talk to each other about labor law. Now, instead of being a labor lawyer, one is an academic or practicing specialist in Title VII or OSHA or pensions or sexual harassment. These are crucially important issues for workers, for employers, and for the community at large, but they are driven by different narratives. They are debated in different forums. They are defined by different concepts and determined according to different public policy considerations than the old labor law. In short, labor law is experiencing difficulty, not just because labor, its real-life social referent, is disappearing or is being disappeared. Labor law is in trouble as well because of powerful centrifugal forces operating within the intellectual and professional field of labor law itself. And now I want to make a third point about the possible disappearance of labor law. Unlike many other fields of law which academics teach and lawyers practice, labor law wasn't organized primarily around a set of legal concepts or doctrines. In fact, one might say that labor law consciously repudiated traditional legal concepts such as property and tort and contract in favor of distinctive social and economic concepts that were better suited to resolving particular forms of conflict and engendering specific forms of cooperation. Consequently, when labor law was first invented as an academic discipline and field of practice in the 1930s, it was particularly susceptible to two influences. The first of these influences was political. Labor law was born during the era of progressivism and the New Deal. During this era, workers' struggles had cultural significance. They inspired a rich folkloric and musical tradition, novels and movies, and especially social reportage. During this era, labor law had great political salience. The Wagner Act was one of the great symbolic achievements of the Roosevelt administration, and it cemented the labor movement into the New Deal coalition, which lasted more or less into the 60s. During this era, the legal rights of labor emerged as one of the great issues agitating intellectuals and policymakers. Unfortunately, this very intense and complex identification of labor law with the politics of a particular historical era left it vulnerable to being considered out of date when that moment passed, as inevitably it would and did. The second early influence on labor law was intellectual. Labor law, more than any other subject in the law school curriculum, except perhaps constitutional law, was the poster child of legal realism. Frankfurter and Green's devastating expose of the abuse of labor injunctions was arguably the most dramatic example of how the realist revolution in legal scholarship ultimately transformed legislation, law teaching, and legal practice. And not just the realists. In the 50s and 60s, labor law featured prominently in Hart and Sachs' writing on the legal process and on Fuller's analysis of the forms and limits of adjudication. In the 70s and 80s, in the literature of critical legal studies. Over the past 2 decades, in studies of informal normativity and reflexive law. However, a domain of legal knowledge and practice that lives by intellectual revolutions runs the risk of perishing in the same way. Law and economics analysis challenged many of the claims of labor law, including its central claim that legal protection for collective bargaining could, should, and would improve the lot of workers who found themselves in a position of inherent inequality. Since law and economics bore the same relation to the dominant political ideas of the Reagan-Bush era as legal realism did to the era of the New Deal, it carried the day. In the eyes of many scholars, students, and policymakers, it delegitimated collective bargaining and with it the old labor law. To summarize, labor law is different from many other fields of law. It has a moral mandate as well as a practical one. Its organizing themes are explicitly political and intellectual, not narrowly conceptual or doctrinal. It's associated with a particular historical era and bears a definite sell-by date that reflects its origins. These are the very characteristics that made labor law so interesting, so compelling for those of us who have committed our careers and personal passions to it. But they have also made labor law vulnerable to shifts in society, the economy, politics, and intellectual fashion to a degree that many other fields of legal study, practice, and scholarship are not. So, is this the way labor law will end? Not with a bang, but with a whimper. I promised at the outset that I was going to end on an optimistic note, and so I shall, indeed, so I must. Mr. McKnight's colleagues didn't endow this lecture in honor of a distinguished labor lawyer, and I didn't come all this way to deliver it, and all of you didn't come out on this somewhat chilly March afternoon to hear it, only to be asked to turn out the lights when we all leave. Cynthia Estland, whose name you heard a short while ago, stood at this podium 2 years ago and argued plausibly that labor law is ossified, perhaps even moribund, and that scholarship in the field enjoys declining prestige. I quote from her writings. Nonetheless, she argued in her 2007 Rush McKnight lecture that by putting law to work, worker participation in workplace governance might be made to rise from the dead. Jack Getman, the 2006 lecture, asked whether blame for the decline of unions can be laid at the feet of labor law. His answer, as I understand it, is that it could, that labor law has failed the collective bargaining system, and that only significant legal reforms can arrest or reverse its decline. My diagnosis and my prescription differ a little from theirs. Contrary to Getman, I think that the decline of labor law can be blamed on the decline of unions, not vice versa. And contrary to Estland, I think that unless the labor movement can somehow be resuscitated first, there isn't much chance that putting law to work will do anything for workplace governance. Nonetheless, as promised, I'm going to try to be optimistic. I've already suggested that labor law's rise in the 30s represented the convergence of two developments, one intellectual, one political. I believe that the survival of labor law, and let me say optimistically, the revival, not just survival, but the revival of labor law, is indeed possible because these same two formative influences are again coming into alignment in a way that may generate a new determination to address workplace inequality and new initiatives to find the legal and institutional means of doing so. Let me say something first about the intellectual side of the equation. However moribund traditional labor law scholarship may be, and I agree with Estland on that point, academic research and writing that deals one way or another with the workplace has never been more prolific, more eclectic, more intellectually sophisticated. Labor law scholars are as stalwart as they ever were in deconstructing doctrine and calling judges to account. They continue to provide insightful commentary on legislative and administrative developments. But these days, labor law draws its energy and inspiration primarily from its engagement with the discourses of gender and race, with organization theory and game theory, with the political economy, of trade and migration, with critical analyses of intellectual property and the rights to privacy, with stakeholder theory and legal pluralism, and not least with history. One way of looking at this flowering of the new labor law scholarship is captured by Hegel's famous aphorism, and I quote it. Translated into English, you'll be relieved to know. One more word, said Hegel, about giving instruction as to what the world ought to be. Philosophy always comes on the scene too late to give that instruction. The owl of Minerva, said Hegel, spreads its wings only with the falling of the dusk. I wish I'd said that. Well, perhaps like philosophy, labor law scholarship arrives too late to give instruction as to what the world ought to be. Perhaps labor law scholarship is so prolific, so interesting, so insightful today, precisely because it has so much to look back on rather than to look forward to. On the other hand, while I'm no Hegel scholar, and I hope there are none in the room, I do observe that 200 years on, people are still doing philosophy, still instructing us on what the world ought to be. Philosophy, like hope, springs eternal. So does the desire to correct injustice. So does the determination of working people to have a say in the governance of their lives. Indeed, today, working people desperately need what labor law promised them in the 30s and the 40s and the 50s. They are experiencing the steepest decline in their current fortunes and future prospects, the most extreme economic inequality, the greatest precariousness of job tenure, and the least individual autonomy and collective agency that they have experienced for generations. They need labor law. But labor law doesn't fall from the skies. It doesn't enact itself or administer itself. It doesn't even empower its intended beneficiaries unless they are ready and willing to be empowered. In other words, labor law can only make its comeback if labor itself reappears as a social as a political, as an economic force to be reckoned with. If it does, if workers are determined to say, yes, we can, as they did in the 30s, then we will know that the time has arrived for us to begin designing new structures of labor law. Which, of course, brings me to politics, the other vital influence in the development of labor law. Only time will tell to what extent President Obama's inauguration was a cause or an effect of a radical disjuncture in American politics. However, it's certainly clear that politics in America have changed, that we are living in a period of momentous and disconcerting events. The collapse of many of our most respected corporations and of markets for goods, services, and credit. The discrediting of long-held beliefs about the potential of those markets to correct themselves, about the nature of corporate governance, about the ability of the present system to deliver on its promises to shareholders, to consumers, and to workers. We are clearly thinking seriously again about the need for regulation, about the corrosive effects of inequality on public interests and private lives, about the disregard for rights and the abuse of privilege, and ultimately about where power should reside and how it should be used. Whoever was inaugurated at the end of January, I suspect, would have to come to grips with these questions. President Obama, it seems to me, in the early stages, seems quite determined to do so. What does all this portend for labor and for labor law? For guidance, we might look with profit to Daniel Rogers' wonderful book, I don't know if any of you know it, called Atlantic Crossings. From the 1880s to the 1930s, Rogers reminds us, American and European social reformers exchanged ideas, observed each other's institutions, developed theories, and designed experiments in progressive policy and administration. During all this time, however, America remained largely resistant to progressive policies on health care, social insurance, public housing, and workers' rights. Resistant, that is, until the Great Depression, when widespread misery led to desperation, and desperation, in turn, to militancy. And militancy suddenly made all conventional wisdom seem foolish. All traditional approaches seem futile. That was the moment Roosevelt seized when he introduced that blizzard of progressive legislation and executive innovation he called the New Deal. And now Rogers' point. Roosevelt's New Deal was only possible because it could draw on what Rogers calls an overstocked warehouse of reform proposals that had been built up by scholars and intellectuals over the previous 50 years. I don't know if indeed America is experiencing a New Deal moment, whether things are getting so miserable, whether people are getting so desperate that we can expect the return of labor militancy. Moreover, if there is a return to militancy, I obviously don't know what form it will take, but I do know that people are unlikely to sit by indefinitely, seeing their interests disregarded, their livelihoods disappear, their hopes dashed. Nor is it in the interest of employers to find themselves reviewing archival film on the great labor conflicts of the 30s and 40s. The best prospects for ensuring that workers play their part in a return to profitable business conditions involve four essential elements. First, workers must develop some sense of common purpose and some capacity for collective action. Second, any new arrangements must ensure that workers enjoy a fair share in the success of the enterprise and a voice in workplace governance. Third, these arrangements must involve the state as the guarantor of fairness and the arbiter of conflicting interests. And fourth, the state must both earn and retain the trust of workers and employers by designing institutions that are effective and even-handed, and by ensuring as well that they stay that way. And now the challenge. The four elements I've described as essential require us to discover or invent the sociological equivalent of 1930s labor, the moral equivalent of the New Deal, the economic equivalent of collective bargaining, and the intellectual equivalent of the Wagner Act. But the originals of all of these have, for better or worse, disappeared, fallen into disrepair, or suffered disrepute. The challenge before us then, as students and workers, as experienced legal professionals and academics, as citizens and stakeholders in a faltering economy, is to restock Rogers' warehouse with reform proposals that are more pertinent to the present. The challenge is clear, the essentials are obvious, and the chance to build a new system of labor law is better than it has been for decades. That, ladies and gentlemen, I say in conclusion, is as close to optimism as my pessimistic nature allows me to come. Thank you so much.
Thank you, Herrick, for that eminently thoughtful presentation about our present predicament and the implications for those of us who are interested in this field. We have time for one or two questions before we adjourn to the reception. So if you have questions, please indicate so. Yeah.
Do you see any areas besides, say, service industry or government or healthcare that now lends itself to an organized labor effort, because given a more global economy, it seems that if anyone in a manufacturing, we'll say, in the manufacturing sector wanted to open a plant in North America, and there was the concern of an organized labor effort, they'll just go elsewhere.
I think a lot depends on whether you spell organized labor with capital or small letters. Organized labor, as we have known it up to now, and there are some clear exceptions to this, has not proved capable of finding organizational strategies to encompass people outside of a limited range of employment sectors. That's clear. It's also clear that elements of the trade union movement, which up to now have not been what you would call leading elements, are experimenting with new organizational strategies, new sets of objectives. I won't attempt to go into all of them, but many of them involve collaborating with forces within communities as opposed to simply individual workplaces, and finding common cause on a whole variety of topics ranging from living wage adopted through municipal ordinances in a number of cities right through to conventional workplace organizing, but on a sectoral basis, for example, in various service industries. A huge amount of experimentation is going to be necessary to find forms of organization that make sense in the contemporary economy. Some of those, by the way, may have to cross national boundaries, and there's experimentation going on in that respect as well. But the notion that you can organize in a specific workplace, that's the conventional unit of organization, in an economy where those workplaces are constantly dissolving and being reconstituted, that's a non-starter. So I can't answer your question, but I think we can begin to tick off a bunch of boxes of what needs to be done if there is to be some resurgence of organization.
Well, I think that was an overarching kind of question, so maybe we'll end it there. I do want to present Harry with just a token of our appreciation for his work today. If I can get it open.
What do we stick with the token, and I'll open it after.
Here we go. No, I want to read this, which is significant. It says, Case Western Reserve University School of Law, January 28th, which was the original date. Harry Arthur's Rush McKnight Labor Law Lecture. So we thank you for your appearance here and your work here. And we also have a tote bag and some goodies for you to take away with you. Thank you so much, Harry. We now have a reception in the outer area of the